to make you start the recording when you started it?
Yeah, I could stop or pause it.
Listening session.
Hi, everyone who's here and online. We're going to get started. We might have some other folks trickle in, and if we do, fantastic. And if not, we'll just have an intimate chat today. So thanks everyone for coming in person, and Anne, it's nice to see you online. So I'll do a quick introduction of the panel and then kind of talk a little bit about what we're going to do, and then we can get started. So we have a panel of 4 folks today, made up of parent side education attorneys. On our far end, Amy Martz. So Amy is an education attorney, the founder and head of Martz Law. Amy was formerly a teacher and a principal, so has a broad wealth of experience. Donna Drown next. The law office of Donna Drown. Donna works in a few areas, but education law is one of her specialties. She was also formerly an educator and also worked with people with severe and persistent mental illness. Thanks for joining us, Donna. Maya Anderson, parent side education attorney for the DLC, one member of our education team here. And then Laura Henry, the DLC's legal director. I'm Katie Cox. I'm a staff attorney here, and I'm also a member of the education team, and I'll be moderating the panel. Generally speaking, we'll be taking questions from the audience, a couple folks in the room and on the screen if anybody else shows up. If you've got questions, if we want to have kind of like a discussion, we can do that. We also have some questions prepared, so we can also talk about those questions, and I'm happy to get us started in that way, or if anyone has any burning questions they want to begin with, we'll do that. If you have a question in the room or online, and if you want to unmute yourself to ask the question, you sure can, or you can type it in the chat, that's your preference. And a couple in the room, just signal to us that you have a question and that you'd like to speak. And we'll get started. Does anyone have a question they want to open with? Otherwise, I can open with.
Where to start, right? How long do you have?
Well, I can start with a question, and then anyone can weigh in with things they'd like to ask. So I think, what do we want to start with? Let's start with the difference, I think, between 504s and IEPs. We know that both can be really good tools. They do different things. They can do some of the same things. So if the panel wants to talk a little bit about how do we differentiate between them? What do they do? When might you want or need one or the other? And then common issues you see from districts around those topics.
I can start.
Okay.
Eligibility for IDEA covers all school-age children, and there are 13 specific areas for consideration. Section 504 covers individuals with disabilities who meet the definition of qualified handicapped person, and that's one who has an impairment that substantially limits major life activities such as walking, seeing, hearing, speaking, breathing, learning, working, caring for oneself, and performing manual tasks. The 2 of them are very cross. I mean, the child could be captured probably in either one of those. Evaluations are the IDEA requires that the child be comprehensively evaluated by a multidisciplinary team. The Section 504 evaluation draws on information from a variety of different individuals and sources. So,
To me, the biggest difference is the protections afforded by each law. So under IDEA, you've got facilitation, mediation, a state complaint, or a due process complaint. So you've got, I always look at it as a triangle, but in that triangle of special protections, there's a way to get help. Under 504, you'd have to go straight to Office of Civil Rights, which from my experience takes a very long time, if ever. I just received a finished complaint from someone who came to me new. It took 3.5 years. So when you're dealing with a 11-year-old or a 15-year-old, people can't wait that long for their child to get help. So to me, I would always fight hard for an IEP if we can get it, because there's better protections, better methods for getting help when things don't go right, and 504 doesn't have that same plan. There are a few similar components, but they're not required and they don't have the same weight. I do hear from a colleague that they might be revamping 504 and they expect it to look more like the IDEA protections, which might change my mind about my preference for an IEP over a 504. The other main difference for me is that a 504 is like, yo kid, you can do these 3 unique things on your own, versus I'm going to teach you how to fix what you don't know how to do. So if it's an issue of behavior, if a 504 might say, he can go into the counselor's office anytime he wants to, versus the counselor's going to pull him 3 times a month and have a 30-minute session with him. So it's an offering of something kid can do versus something adults are going to do to make sure the child gets what they need. So that's my preference, is always for IEP under those circumstances.
Just add on to that a little bit. So it's interesting what you said about the federal government potentially looking at revamping some of the 504 regulations. That's I haven't heard of that first. That's interesting. I'm not sure if exciting is the right word. Interesting for sure. You never know. You're gonna tinker with stuff. It's gonna be better or worse. To me, basically, the way I like to think of IEPs, which IEP, you can think of IEP and IDEA, the Individuals with Disabilities Education Act is the law of IEPs. So there's 2 things go hand in hand. So you have this one world of IDEA and IEPs, which is special education. You have this other world of civil rights and accommodations, basically, which is 504. So the way I like to distinguish it is basically IEPs, we're talking mostly about the substantive content of education, basically. So the IDEA and having an IEP entitles you to what's called special education, which is actual modification to that educational content, like I was saying. So, we call that special education, specially designed instruction. These are all kind of synonyms, basically. And so in order to actually be qualified for specially designed instruction, you have to be qualified for an IEP. You can't obtain specially designed instruction, formally speaking, through 504, basically. So Section 504 plan is sometimes called an accommodation plan. Basically, it's accommodation. So under an IEP, we're talking about, you can have accommodations that are listed under an IEP as well. You can have accommodations and special education. Under a 504 plan, you can only have accommodations, basically what we call related services. So anything that a student needs in order to be able to access the services that they would otherwise be receiving, in their educational environment, whether that's through an IEP, whatever they need to be able to access their IEP services, or for students who are just qualified under 504 and don't have an IEP, whatever they need just to be able to access their educational environment in general. So, things like, physical access to the classroom, or transportation to be able to get to the classroom. These are things that would be considered an accommodation or a related service that would be available under Section 504. You could get that through a Section 504 plan. When we start looking at things like actually modifying homework assignments and changing the curriculum itself, that starts to get into something that only the IDEA will be able to cover. But generally speaking, anything that you can put on a 504 plan, that can also be on an IEP. But the opposite is not always true. Basically, an IEP gets you access to more things, more stuff than a Section 504 plan would. So again, talking about special education in the IEP context versus accommodations, civil rights in the 504 context.
And I would just add that I agree with everything that's already been said. I would also say that the Americans with Disabilities Act, or the ADA, also applies to schools and school districts, although it never gets brought up, weirdly. And in a lot of ways, it mirrors 504. 504 falls under the Rehabilitation Act, but I think it's important to just recognize that children with disabilities in a school context are, at least they should be, protected from discrimination, right? And the IDEA is really not an anti-discrimination statute. There's case law about that. And so sometimes when parents sort of use those kinds of words when they're talking about how they feel like their kid has been treated, that's really another signal that you're probably more in 504 ADA land in terms of the consequences of the school district's conduct. So I would just put that out there because I think it's really important to know. The Supreme Court likes to act like it's a very clear line. What is like the ADA and what is the IDEA? You know, like the case about this was a service animal, but then you get into the nitty gritty of it, and it's actually just like very, very complicated. And like, you know, you could have 4 different lawyers with 4 different ideas about it. But I think it is really important still to know that the IDEA, 504 of the Rehab Act, and the ADA all apply to kids in schools, and you shouldn't sort of leave any protection on the table.
Thank you, everyone.
May I
Yes, please.
kind of throw out there, one of the things, and correct me if I'm wrong, that when I'm trying to communicate to parents, IEP versus 504, is the IEP is quite literally a legal contract with the district and has a lot more legal weight than the 504. So like really, like when I'm talking to them is, you know, making sure every single piece of that legal document of that IEP is ironed out for your child's benefit. So just for clarity's sake for myself and others, like that level of protection for that child, IEP versus 504. So not just that access piece, but also the level of protection that one provides versus the other. How does that compare?
I would hesitate to say, let me step back. If you can get an IEP, get the IEP. So I don't want to be unclear on that, but there are also sort of different kinds of protection, right? Because again, if your kid is being discriminated against on the basis of their disability, that's really not what an IEP is going to help with. And so I think it really depends on the issue that they're facing. The really great thing about the IDEA is that it has this robust set of like procedural safeguards. You don't have to wait 3.5 years in a dark void. You know, you'll get a response. Now it might not be the response that you want, but you'll get one, you know, and the timelines are finite. And so that's a really good process. And it's very specific about, you know, the procedures and who does them and what rights parents have, whereas the discrimination statutes are a little bit more vague about how long it takes and what it looks like. But I wouldn't say that the protection isn't good, because it is and it should be. It's just it's probably going to take longer, and it's for a different set of problems.
It'd be a more expensive fix. Some of the IDEA fixes are free to you. If you go OCR or do a lawsuit, that's expensive.
I do think so. I think what you're trying to get at, Amanda, is that like in situations where like, because there is a lot of overlap there, you know, there are some things that are very cleanly kind of within the special education context. There are some things, like Laura was saying, that are very kind of cleanly within that civil rights accommodation discrimination context. But in situations where it overlaps, basically, if you're looking at something that could be considered an accommodation, it could potentially also be considered an IEP service. I don't know that I would go so far as to call it a contract, but it is more enforceable. And like Laura was saying, those procedural safeguards that you have access to under the IDEA give you a lot of power to address your concerns that under a 504 plan you wouldn't otherwise have. Like if you have something that's listed in an IDEA, in an IEP, if you have a certain number of minutes of a certain service, first of all, it'll be listed out in terms of minutes. That's not something you're likely to have under a 504 plan, although you could theoretically. Something that say you couldn't necessarily, but you're guaranteed to have, you know, this number of minutes. And then if those minutes are not provided, you have the ability to go back and seek a recourse for that and get, you know, compensatory education. For instance, if you have something that's in a 504 plan, they shouldn't be denying you your accommodations that's in a 504 plan. But it's a lot more, you know, they don't even have to, strictly speaking, be written down. They should always be written down, but legally they're not required to be. So it can be a lot more difficult to go back and fight then over, you know, the meaning of what something in a 504 plan, you know, what that entitles you to, and you know, exactly when there is a violation if something is not provided. With an IEP, whatever is in that document, that's what you're entitled to, basically. With 504, there is, some wiggle room to be had there, but like with respect to those things that like, yeah, if it could go either way, an IEP is going to give you more protection just because of the procedural safeguards of the IDEA are, different than the ones under 504. Basically, you have an ability to enforce that document in a way that you wouldn't as easily, I guess I would say, under 504.
I have at times strategically used the 504 to get more immediate assistance to the student, and then move forward with the IDEA. And so they're just different
So
tools.
basically get them on a 504 while you're working towards getting them on the IEP. basically.
Exactly.
Gotcha.
And then the 504 actually serves as evidence of the necessity of the IEP, depending on what the conditions are.
I said one quick thing, and you're absolutely right. If it doesn't go on to the IEP, it doesn't exist. So you've got your right to push really hard to try to get everything you need in writing. You're supposed we call it the stranger test. You're supposed to be able to pick it up and move it to Kansas, and they'll say, great, we know exactly what to do. So that doesn't always happen. A lot of times schools, especially junior highs, will say, well, we do that for all of our students, so we're not going to write that down. It's like, well, if I picked it up and moved it, they wouldn't know what to do. So let's get it in there. You're going to write it down. Yeah.
And in 504, the bar for eligibility isn't as high, right? Because the definition of disability is what Donna said. There's no requirement that the disability necessarily like affect your learning. It's that you have sort of a demonstrated disability. And I know sometimes with eligibility, that's where you get into fights about like, but does this affect this or that, but if you have very clearly from, a pediatrician or whatever that this kiddo has a disability, like that really should be enough for a 504. And so that's another way for speed that you could like get some accommodations in place.
Yeah, that's a great way to do that, because I went through that with another kid. I feel like my family is just the example of every spectrum that can happen in a family. But it was really eye-opening how, the qualification expectations are just, thankfully for her, it was just, okay, this is weird.
Jumping from that, I think we've been talking a fair amount. Anytime anyone has other questions, let us know. But because we have been talking about sort of some interventions or dispute resolution options, those kinds of things, why don't we talk a little bit about sort of what kinds of options are available to parents if they disagree with an IEP team's decisions, for example, and what that looks like. And we alluded to some cost components and some other things. So let's open it up.
Has a good
All right, I'll jump in. Where's my triangle? So facilitation is the lowest, what I call lowest level. If you've got a team, maybe that's not communicating well, or you've got someone who's doing all the talking and you feel like you can't get a word in edgewise, so that they know this person, you would invite a facilitator to come in and they would just make sure everyone gets a chance to speak. What do you think, Mom? What do you think, teacher? So they just sort of get people discussing. The next level to me is mediation. So then you could say, hey, we don't do very well in the same room. Could we go with Mom and attorney in this other room, and the school people can be over here, and the mediator will go back and forth. With Zoom, of course, that's very easy because you can just appear in this room and then appear in that room. And the mediator tries to keep the heat down by communicating back and forth to the parties. What a mediation can't do is say, we'll put these 4 things in your IEP. So that's not something that can be accomplished in mediation. They can say, we'd be glad to have an IEP meeting and consider those 4 things, but you're not going to get those 4 things out of mediation. The next level up then is state complaint. Essentially, you're saying, hey, we think the school did something wrong. Would you send an investigator who knows special ed to come look through the documents and talk to both sides and tell us if you think there's been something procedural that's wrong? We have good results in Utah, like 70% of state complaints that get finished will identify a concern that's true, that a school made a mistake. It'd be very easy to find because it's very thorough law that's very complicated. As a principal or a teacher, you could have opened any one of my files and found something wrong. It's just almost impossible to do it perfectly. As an attorney, I don't look for things like a date that's off by 2 days or something like that. We're looking for much bigger issues. And then the big kahuna of help is called a due process hearing. It's miserable, so we recommend you enjoy it. I think we've all, you haven't had one this year, but we have all had one. I had 2 already. But it's essentially a trial. And so there's exhibits and witnesses and cross-examinations and motions. And I mean, it just really is nothing short of a trial, except there's informal rules, which actually makes it worse. Because then you don't have these consistent things. And the one hearing officer I just knew, and I was trying to say, hey, I don't understand your decision. This is my first hearing. Could you explain why you made that decision? And he says, for my many years as a due process hearing officer, I was like, okay. So that's what's difficult about due process. And so for 17 years in Utah, not a single family had won. But in the last 7, we have won 4. So we're really, this group and a couple others are turning that barge, and we've seen some good changes happening. So we're excited. We used to go into due process and say, we're going to lose, but you must do that to get onto federal court. But now we're like, hey, there might be a chance. And Maya she won hers this year. So Laura's got one in the works. We're waiting to hear back, and then I start one on Friday. So
I'll see it.
in my 3rd this calendar year. So it's rough. It's not bad.
It's very stressful. And I think what Amy said is right. It's like, because they're informal, that does make it more difficult, because you, at least in real court, in front, like, you know what the rules are, and like, maybe they're hard, but like, you know what they are, and it could be totally different. Like, Maya's gonna have a hearing where they want to admit all of the exhibits up front. In the one I did, we had to go every single one and admit and lay a foundation, and it's just like very different. And you don't know until the hearing officer tells you what they want to do.
And not all hearing officers are created equal. That's all I'll say about that.
Very true.
Nicknames will not be revealed.
Fair.
Anyone else want to weigh in on that? I think the only sort of question I have or follow-up I have on that is what I've heard USBE dispute resolution folks say in the past is to remember that mediation is available at any time. And so that you can sort of employ mediation after a state complaint, for example. And so I think that that's really interesting, because we do sort of think about it as a continuum. But if you can sort of jog in some of those tools.
And so one example, right, is that if you're awarded compensatory
Mhm.
services,
Yep.
then the State Board of Education likes to have that done within a year. But that's not always beneficial to the family if you've been fighting about who's going to provide them and when the kid is getting these extra minutes, because the kid still has all of their everyday services. And so compensatory services are adding on top of that. And so you don't want to make it so it's like this poor kid and family's full-time job when it was the school district's error in the first place. So I don't know about you, but that's something we have seen where you're trying to fit in compensatory education, but it's like almost becoming a punishment for the kid. And so USBE is very clear that they want that to be done within a year, but you could mediate basically between you and the district to say, we will agree that it can go longer. So that has been
So USBE
a
can then,
reasonably useful tool.
they can meet their obligations. And then under OSEP, and then, but the student can still get the things they need. So that was really interesting use of that tool.
That's an excellent point. It's like with my daughter, she's got a tutor, and then they're like, if we miss something, well, do you want to make it up? Nope. I'm stretched completely thin, so. So that's really good to be paying attention to that.
A good success was summer.
Mhm.
So let's do a 2 hours a day for 4 days, just sort of building in more. Things are quieter, things are less stressful. So we had some willingness from the district to find somebody because of people are available. So that I would never do comp ed on Saturday. I tried Saturday, I tried after school, I've tried Friday afternoons. Really, summertime is the only one that really feels like a benefit and not a punishment for the families.
Well, I'll ask unless anyone has a question.
I had just a kind of a comment to add on. You said you can do a state complaint. Meanwhile, while there's a due process in the works?
No.
Okay,
Yeah.
you're talking about OCR complaint.
Correct.
Yeah.
If I filed a state
Just making
complaint
sure
and due
we're-
process at the same time, they'd say, which one do you want?
Right.
Because they can't both be done at once. The trouble with OCR is they'll say, oh, do you have a state complaint or a due process going? Okay, then we'll just wait and see how that turns out. And then you'll say, okay, it turned out like this. Okay, then we're out of here. Like they accept whatever state resolution you get, and they don't often pursue it themselves after that. So they often defer to the state systems, which have been unsuccessful prior to this last 2 years.
Would you say that it's still a good idea to submit that OCR complaint so it's documented?
I call it spray and pray, and yes, I often do at least a couple things at the same time.
And if you can bifurcate the issues, like usually if you're submitting one of these things, like lots of things are going wrong. And so if there's a way to like draw a nice line of like, these things are very clearly discrimination-y things that I don't have to talk
Yeah.
about in my state complaint, because yes, once you start talking about them, they'll do the pause that Amy's talking about. But if you can say, like, I'm not getting interpreters to go to this after-school activity, for example, and I'm also having a bunch of problems in my IEP, but like, I don't have to talk about the interpreters at the after-school activity to talk about my FAPE, then you can sort of like splice that part off and put that part in OCR, if that makes sense, and then try it that way. And then you're waiting for however long you're waiting. OCR does take a long time. They also have mediation. Sometimes if you get a faster result for OCR, it's because you've been selected for mediation. So it's not necessarily the case that it will take years, but it certainly is frequently the case that it'll take years.
Denver seems to be worse than other areas, so ours is slow.
Thank you.
Well, summer was mentioned. Return to summer. Let's talk a little bit about extended school year or ESY services. Can we talk about who gets ESY and why? ESY discussion.
Yes, why? I'll go for that. So extended school year is a service that is available under the IDEA. And it's for students who've experienced some sort of regression basically over the course of the previous school year. So if you have, if you have a student who, or I guess I should say, who has experienced regression, or who you have information that suggests the student is likely to experience regression over the course of the summer, if they're not provided with some sort of update, basically. So if you've been fighting on, to get your students' reading level up to a certain point, and you just know that, having those 3 months off is going to, cause a backslide and, maybe even end up further back along, than you even started, then you can get extended school year services through the IEP, and that's something that should be listed on the IEP. It should be marked specifically that the student qualifies for ESI services, and it should, go into the details of like where that's going to be provided, what that'll look like, just like it would for any other sort of like minutes that you would have under the IEP for anything else, basically. So the problems that come up, I think, a lot of times with ESY is like schools setting policies that interfere with students' ability to access ESY, or setting sort of limits on like how much ESY a student can get, or saying that only students with a certain classification or category are able to access ESY. All of those are things that we've seen before. But really the requirement is just, if you think that if your student has experienced regression, or you think they're going to experience regression, that's the only thing that like legally speaking should speak to whether or not your student qualifies. If the school has a policy that says otherwise, then it's superseded by the IDEA. The IDEA says the student is entitled to, whatever it is they need in order to make appropriate progress based on their disability. If they need extended school year, then they're entitled to extended school year, basically. But other than that, the actual content of the ESY can look like anything that regular school looks like. They could have a one-on-one person, working with them on their IEP goals. They might be in a group with other students if there's other students there. It really is sort of the sky's the limit. Whatever, the individual student is going to need to help them manage their regression. You know, just like you would, just same question you'd be asking in an IEP meeting otherwise. What is it that this kid needs in order to make appropriate progress? You know, what does the student need to avoid having this harmful regression happen?
Anything else anyone else wants to weigh in on? It was comprehensive, Maya. Thank you.
That's why it's like a thorn in my side. Like it takes so much work to try to get it. And it's such a small offering. Like normal is like 3 weeks, 4 days a week, 2 to 4 hours a day, and that's it. And so to me, it's almost not worth fighting for because it's such a small benefit. And then I fear it's more like babysitting than it is true instruction. So but I haven't had a lot of firsthand experience, but that's what parents say to me. Is they didn't notice it was especially helpful. So it could be so much more. Like that's what's sad about it.
I think it's just very annoying because I go to so many IEP meetings where it's just a foregone conclusion that the kid doesn't need it. And I feel like, well, maybe that's why your ESY programs are terrible because you don't provide it to all of the children you should, and therefore you don't have to think about how to make it meaningful. So I struggle with this in a lot of ways because I think Amy's probably right. It's really not worth fighting about in the grand scheme of things. But I get so upset because I'm like, you have no data to suggest that this isn't appropriate. And most frequently it's because the kid is in a certain class or placement or has a certain disability, and they'll say to you, we don't do that for these kids. And you're like, well, no, like that's completely inappropriate. And so I am a practical person at the end of the day. Like you do have to decide, you do have to choose your battles, but I will just say my experience is as a state, we are horrific at this. Like it shouldn't be this like unicorn service. Like it should just be a thing. And I think lots of kids do regress over the summer, and there's literally a thing that is supposed to prevent that. And we just like write it off and don't discuss it. And so I guess for me, it is the ease with which people just decide that kids don't need it based on, I can't tell what, based on nothing, that makes me personally irked about it.
And I think that like that same kind of like, you know, even knowing that that is the case, and it certainly is, it does mean that like you as a parent are in the position to push back. And if you feel very strongly about this, I mean, honestly, this goes to a lot of things within the IEP context, basically. But that, you know, people might think that IEPs, you know, are a battle of facts and, you know, data and evidence. And there's a lot of evidence that's exchanged back and forth, but it's just as much a, you know, game of rhetoric and, you know, argumentation as it is anything else. If you can like prove and show and speaking to the people who are there at the table, explain yourself, you know, why you think this is appropriate, why you think the student actually needs that. And that's somewhere where I will usually, if there's something you feel strongly about, use the language that you feel strongly about. If you think your student needs a certain service to be able to benefit from their education, you know, you don't need to hedge your language. You absolutely go there and you say, my student actually needs this. You know, we like to, and there's some contexts where we like to avoid speaking in absolutes. I honestly think this is not one of those areas. If you can speak in absolutes, if you can tell them, my student actually needs this, it's not negotiable. My kid needs this service in order to be able to make appropriate progress. If this service is not provided, they are not going to make the appropriate progress. You know, if you can be very unequivocal about those things, that can actually be helpful because it shows that you've thought it through, that this isn't just, you know, that you're not just a parent who's just, you know, trying to get their way or the highway. Like you actually like believe strongly in what it is that you're pushing for, and, you know, at very least genuinely reasonably believe that that's going to be something that could be helpful. And so with ESY, like with a lot of things, if you feel very strongly that your student needs ESY and you're getting pushback from the school district, you know, don't take no for an answer. You can absolutely speak up and say, well, I think, you know, for this and this reasons, like we actually think that our student does in fact need that, you know, as a service. And, you know, in a lot of situations, you know, you'll get school districts that are not going to listen no matter what you say, but in some situations you will be able to. And I have had success just basically, you know, providing that pushback. Well, why are we saying that? You know, do we really have evidence to show that the student doesn't actually require this? Have we actually fully talked to everybody that might have some sort of input as to whether this, you know, may be the case, or we're making an informed decision, or are we just sort of coming to, you know, a bunch of assumptions that we're putting together essentially? So, you know, it's something that you can give a lot of thought to and consideration basically, and the sorts of things that you feel like you want to push for, you absolutely can and should push for. And, really it's just a matter of coming to the table with, having thought about, what are the reasons for why I think that this is going to be appropriate and being able to articulate those.
I've seen the same systemic issues that Amy's talked about with regard to students in elementary education and high school students, but I've actually seen some really good results with students who are at that early childhood education level. I've seen, and I think that's really where the biggest bang for the buck is as far as the school systems go, because the disabilities are addressed early on, and they're taken care of early on, and kids are, they learn how to learn at that early age. And I've seen some real success at that very young age. I don't know, have you?
Preschool is the champion of all levels of
Yeah,
education. Like they do it better than everybody else.
But that is the place I would say that I've noticed the most success.
I'm glad you brought that up. That's something that I found a lot of people don't even know about, basically, like the fact that you have access to early intervention services. IDEA eligibility doesn't start when you're eligible for preschool or kindergarten. It starts at birth, basically. Like when you are, from birth all the way up through the age of 3, you have access to early intervention, and you can get what's called an IFSP, an Individualized Family Services Plan, which is very similar to an IEP. It's got some differences, but it's a lot of similarities as well. And you can get related services like speech therapy for students who have developmental delays, and occupational therapy. And like Amy was saying, basically, it can be really critical, as a student is transitioning from, life before school to life in school, to get them set up and have an expectation of, if they're going to be, if they've already, had the good fortune of having an early identification, early access to those supports and services, to get them used to what accessing those services is going to be like, for students who are able to advocate for themselves, for them to be able to start building some of those independent living skills, and to be able to speak to their teacher and say, I need to have a sensory break, or those other things that really require a lot of initiative on the student's part, to get them used to what the experience of being a student with a disability and having accommodations and supports available to you would be an incredible benefit to them as they're transitioning to getting more and more independence in their daily life from early childhood up through elementary school, and as they develop further. So that's something that a lot of people don't know about, that you can have access to that. It really is just a matter of finding out who your local provider for that is. It's usually through the public health department rather than through the school districts. So that's something that a lot of people don't know about as well. But if you get on, if you contact your local person, your early intervention specialist, get on an IFSP, get your evaluations done, you have access to all of these related services that could help your student before they're even started in their first day of preschool or kindergarten. So absolutely, those are resources that are underutilized, I would say.
And it's the very best time for the student to receive the help that the student needs.
Get back money as a state every year, because we're not giving it out to kids, so we gotta do better.
With a couple of just logistic questions, can the people online hear? Okay,
Yes, we've checked in with them.
awesome. Okay, is this being recorded?
Yes.
Okay, great. I have a question about aging out of early intervention services, and then going into the district for preschool. I just helped a family to advocate in a district where they didn't allow the student to be in a least restrictive environment. They had them go directly into a special education classroom, because they don't offer that for kids who are not 3 by September 1st. How do they say that that is compliant with IDEA? And what recourse, what step would the family say, okay, you can, they can choose to reject their offer of FAPE, right? So we went through the whole IEP process with them, and I will send them this recording. So I'm like, okay, just go through the process, do the IEP, check the boxes, and then you can start listing, they're not going to be able to get meaningful inclusion in that setting. nor is an hour a week sufficient.
This is just for a student who's in pre-K still.
Just not quite through yet. So just getting the initial IEP started.
So what do the services look like? I think I'm a little confused about that.
Yeah, so, well, what I found interesting was other districts might just implement them, like add them straight into the 3-year-old classroom. And they said, well, because we have a 2-year-old classroom, we can put them in with other students who aren't yet 3 by the beginning of the school year. But I'm like, but then you're putting them in a special setting. Then you're not allowing them to enjoy having the least restrictive environment and modeling of appropriate behavior and, you know, norms of age appropriateness with having all the benefits of being in the least restrictive environments. There's no offer of FAPE in the LRE at all.
So they put them in the 2nd grade class the entire year.
They keep them in the age 2.
Yeah, 2nd.
Age 2 for until they are 3, and then those same kids would go into the age 3 classroom, but I'm like, an hour a week? Are you
That's
kidding
the
me?
offers. It's 2-year-old preschool, 1 hour a week until they turn 3.
Right,
Interesting. And those are all special needs kids with
yes, everyone with an IEP. So I was like, I don't know how you could, like, you're spending more time creating the IEP at that point than they're actually gonna be in the classroom. So I was like, why even do the work? So I'm like, okay, so at what point would the family then go to the state and say, hey, we believe this is not compliant with FAPE because LRE and many different reasons. You know, if they're getting IEP services, you're going to be having to pull them out of that time or pushing in, which is good. But an hour a week is less than what they were getting in early intervention. It's decreasing instead of maximizing, you know, the offer of the student. So at what point would they then say, okay, this is where we should, because we've already done the IEP and there's limited amount you can do because their offer within the district is all they're offering.
It's a very good question. I don't know the answer.
I didn't know that this is even a thing, that there was 2-year-old
Yeah.
preschool outside of
I
Head
think
Start or
I think
something.
it's very case specific. It depends on exactly what disabilities are being addressed, what you know, what the current rate of intervention is. Do you see what I'm saying? So it's very, like, you've asked a very context specific question, and so and the variabilities change, the answer might change. So you see what I'm
Yeah.
saying? The answer would
Yeah,
change.
so it's not a mild or moderate disability, it's a visual impairment. So how would you guide them with next steps is my question.
I will tell you, I don't know the particulars of this being sort of like the age group, because I think that does throw a wrinkle into it. And I am not an expert in the early childhood, so I will defer to this part of the table in that. But I am fighting about this issue in another context, which is sort of what Donna said is absolutely right? Like, it's case specific. It's about the kid. And the problem is that districts don't make it case specific. The problem is districts say, this is what we do for all kids. And then they do that. And that really is the problem. And I think our take would be that that is unlawful. But I'll tell you, the problem is that, like, that has just been accepted for a really long time. Right. And so pushing back against that is very, very hard. That's why we were fighting about this at the 10th Circuit on like very similar fact pattern, just older kids. And so, I mean, I hope there's a day where I can tell you, like, we have a really good decision on that, but there also might be a really bad decision. I mean, I think keep bringing it up, because I think districts, like, they've just been used to doing that for so long that they haven't taken the time to develop the services that are more individualized. Like, why does a kid with a visual impairment need to do that? Like, I have no idea why. But the problem is the district doesn't have the framework, right? They're like, we have one thing we do and this is what we do, so what do you want? But, like, that is really antithetical to the IDEA, which is about individualized services. So I don't have good answers for you or them, but I would say, like, keep harping on it, because I do believe that, especially sort of this generation of parents has been very outspoken about it in a way that, and this isn't like blame, like, people have a lot on their plates. I just mean, I think pushing the issue is making
incremental change, and I think we can see that. I think it's really important, even when they're giving bad answers. And if and when we ever get a decision, we'll post it on our website, good, bad, or indifferent.
One thing that could be done is sort of a response to intervention. So if they say that you get one, what was it, 1 hour a week? So in 3 or 4 weeks, then you request them to analyze this intervention that they've provided. And the important part of this is make sure that they document it, because I don't know about you, but the thing I've noticed most about districts is if it's not documented, they didn't say it. So they can promise you and promise you can call them and they'll promise you, look, oh, the head's not, they will promise you all this stuff on the phone. You follow up with an email that says on such and such date, we had this conversation and these are the things that you told me. And if that's not correct, email me back. And all of a sudden, they're not willing to commit on paper, not even in the form of an email. So if that's going to be the intervention, then in 4 weeks, the parent needs to go to them and say, look, you provided this service for 4 weeks. I want to see whether or not there's a discernible change. And then, so they can have the conversation, but then send an email and give them a due date. And even if the due date's not something that they have to follow up on, it creates a system of accountability. Yeah.
Do they do prior written notice for early childhood stuff? Because
had
that was my other thing is like, please, for the love, everyone get a prior written notice, because then when they say no, like, a parent will be like, I've been asking for this all the time. And in every IEP meeting, they basically tell me that I didn't really want it. And you're like, no, I think I did. That's why I asked for it, but that's like, somehow at the end of the day, they're like, the parent is like, I guess I said I didn't want it. And it's like years of this. And so a prior written notice forces them to commit to a position and then, at least in theory, explain why. So if they're like, absolutely not, this child has a visual impairment and only can have 1 hour per week, and the parent is like, no, we want more, then they should write down on a paper why that is. And I do find that sometimes when they're forced to be like, why is it that we think that, and have to write it down, that can help.
Well, and I had an experience one time in an IEP meeting where the district refused to provide certain services that we had asked for. And at the end of the meeting, everyone is supposed to sign the meeting minutes. And when I reviewed the minutes before signing them, that information, that denial wasn't there. And I said, look, you guys need to include this in these minutes. And they said, well, we're not including them in the minutes because we're not providing the services. And I said, you need to include in the minutes that you're refusing to provide these services. And so then they went back and they actually ended up providing the services. They did not want to document that they weren't going to provide services. So have you seen that sort
I
of
do
thing?
that all the time.
Yeah.
If you're in a conflict in a meeting and you've asked and you're sort of a loggerhead, I just do this, it's okay. Just put it into a prior written notice and I will do with that what I need to. Then you can pick that up and file a state complaint and attach that. See attached, this is what they said they wouldn't do. So it gives you that, like, you don't have to fight about it. If you're gonna say no, that's okay. Say no and give it to me in writing. And then I will do with it what I need to do to move on to the next step. So I would recommend a state complaint. I'd love to see how it turned out. I don't know what you get. I couldn't predict what they would say, but it'd be lovely to say, here are our reasons why we asked. Here is why they said no. What do you think, state complaint investigator? I think that's lovely.
Because the state complaints are quite quick,
Yeah.
informal. You don't have to do like this big, like legal
It's
thing,
not a
like
hard
with the due
form,
process. You're basically bringing these things to their attention. And then, like you said, they investigate and they do it fairly quickly. So that would be a quick way to get the state up in their junk and kind of analyzing whether they feel it's appropriate or not.
Sure. I have seen outside the IEPs for preschool outside of Utah come in with a full week of preschool, there's some beautiful, amazing preschool IEP.
Very targeted.
And then they try to shove them into the 3 hours, twice a week. And so we have been able to stretch that. So we got mornings 4 days a week and afternoons 2 days a week in the special cluster class. And mom was like, okay, I can settle for that. But that was the only way I've ever seen more be allocated, is when they come from outside of the state with a better IEP than the services that we're currently offering. And it we at least compromised a little bit. So
I'm not understanding all the nuances. Whenever Tori started in our district pre-K, there was no inclusion option at all. And so I went right to the board members at that time and the new special education director at the time, and they brought it to the lawyer at that time, because I was like, hands down, this is a blatant violation, and within 6 months, they fixed that. And so they like course corrected.
We had the
So
same scenario. They just kept saying, oh, we have a special classroom. And I was like, no, if I need to explain this to you,
Right.
you do not get access to my kid, period. That's what I said. I was like, no, we'll put her elsewhere.
Yeah.
I'm not gonna deal with you. I don't need to be the one to
for
explain
my
to you
thing,
about
though,
low
they fixed it
expectations.
like district-wide. So it wasn't just getting that resolved for my
Oh,
daughter
they
thing.
didn't by the time my kid got there,
Gotcha.
because we're in the same district.
Yeah.
So they kept offering special placement instead of, and I was like, no. Unfortunately, yeah, we've never been in our district.
Well, that's a
My
good
kid's in
point
fifth grade.
about like conflict and
Yes, that was purely pre-K that she got that, and then it went downward.
Yeah, she was born into condition, so it's like they never offered.
it's a good point about
LA.
conflict and trying to make change. You have to take care of your kid first. If pushing a district or fighting for something, if you have the stamina and the energy, please do, whoever's out there. But you have to stay afloat. And when we are parents of hard kids, we're already working really hard. We're attending, T or speech or whatever it is. So you kind of do for it's like your mask thing. You do for your own first, and then as much as you can press, because it's making change. So every time everyone's fighting a little bit over something like ESY, it makes a difference and things are moving. It just doesn't feel like it, but don't feel like you have to save the world. You take care of yours first, and then as much as you can, press for somebody else's kid.
And speaking of advice, I think that's the next question I'd like to turn to. And we've already heard a lot of really great tips, I think, but I'd like to ask each panelist to maybe share a couple of practical tips for parents when you're advocating for your students with the IEP team or with the district. For example, if a parent disagrees with the services or doesn't like the goals, sort of how should they communicate that? And you've all sort of pointed at that a little bit throughout our conversations, but just any direct advice you have for parents about the way they should be articulating things, putting things on the record.
Either way, I'm good either. Right. I would say the biggest thing I've seen in meeting with parents is they have a reticence to have a direct conflict with the district and they've said it repeatedly, because my student is going to be in this school district for 12 years, and I don't want to butt heads with everyone, because I don't want them to not give my kid what they need because I have a conflict with the district. And I've told them, look, the squeaky wheel will get if anyone gets the oil, it'll be the squeaky wheel. But the other thing that I think is so important is any oral conversation you have with any member of the district, you go home and send them an email and state exactly what was said, and then state to them that if they disagree with that, any part of this email, if you disagree with any part of this email, please send a reply email and correct me where I was wrong. And do it every single time, because I've seen districts over and over and over say that they will provide services as long as they're saying it orally, but as soon as it needs to be written down, they won't do it. When you go to an IEP meeting, make sure that the meeting minutes reflect what actually happened in the IEP meeting. What I've noticed for me is that if I assist a parent from the get-go, or if I give that same advice to parents from the get-go, it often doesn't ever elevate to the point of a due process meeting or a mediation, because all of the information that's necessary to succeed in a case is there, and the district knows it's there. Especially, and so document, advocate for your kid, and don't worry about making the district angry, because the district only has so much money, and the squeaky wheel gets the oil.
It's true. Go there. I'll give you a accordion.
Yeah, so I guess I've sort of hinted at this already, but like One of the things that I often hear from parents is sort of on a similar note that Donna was talking about, like folks are really worried that, I don't want to seem like I am unreasonable. I don't want to seem like I'm a difficult parent. I don't want to be making people's lives harder or anything like that. And I can say that having, been on a lot of the IEP meetings before and having, worked with lots of different clients, it's pretty, like, in my mind, it's pretty easy to tell the difference between somebody who is persistent, persistently advocating for their student, in a way that like people might not agree with and that, might cause conflict just by virtue of the fact that they're not going to back down, versus somebody who is just trying to get under people's skin, and is just genuinely trying to make things harder and is not there in good faith and is just trying to, drag out the process or make it, more difficult than it needs to be. And everybody who's there in the room can tell the difference between those two things as well. And if you're being a zealous advocate, if you're speaking your mind and you're not going to back down because it's genuinely what you believe and you think that's really what your student needs, you have every right to do that, and if people are going to react negatively to that, if people are going to, give you grief because you're not going to back down from what you think is real and true about your student, even if, a lot of people who are on the school district side don't agree, it's your right to disagree and to have your own opinion and to present that opinion and to have your voice meaningfully heard as part of that conversation, and so feel empowered and confident in advocating and in making requests and in being persistent, not taking no for an answer. And again, like, if you get to that point where it's like we're just going in circles, spinning the wheels, I've said my piece, they've said their piece, we're just doing this over and over again. At that point, you can request prior written notice, basically, for those of you who are unfamiliar, you can make them provide you a written explanation of why they're going to deny something that you've requested. And at that point, if I'm in an IEP meeting and I think that, the conversation's getting heated, we disagree, and one side thinks one thing, the other side thinks another thing, we'll say our piece. Once I've sort of detected that it's kind of, we're treading water, going over the same things we've already said, I'll just say, okay, you know what, I think that it's time to move on. We're going to be requesting prior written notice. Please provide that to us within, the amount of time, and let's move on to the next thing, basically, say your piece, get it out, get it on the record, and be done with it, basically. And that way you don't have to worry later on about, oh, was I being too forceful? Was I, being unreasonable about bringing this to the table? It's like, nope, you checked all of those boxes off, got what you needed to get on the record, said what you needed to say, and then you can go after, dispute resolution and work out anything that is truly gonna, come to that, basically. And then other than that, like, being honest and truthful about your feelings about what your student needs. Like I was saying earlier, if you think that your student really needs something, you can absolutely speak in terms of like, this is something that I need. There is no other option for my student in my mind. This is my opinion. That's your opinion. You're entitled to it. You can disagree. They can disagree. That's totally fine. But you are entirely within your right to be the squeaky wheel, like folks are saying. That's what you would expect of a parent. If somebody else was in your situation, that's what you'd expect for them to do, and your kid will be grateful to you, later on in their life when they hear about everything that you did for them and earlier in their life, making sure they had access to what they needed, in their education. They'll be like, Mom, Dad, thank you so much for being persistent, and fighting for me. It'll make the absolute world to them that you stuck up for them when they needed it. So know the difference between being a gadfly or being there to be annoying versus being zealous and persistent. There is a difference, and you can absolutely be zealous and persistent without just trying to get under people's skin.
Yeah, this has already been really good, so I'll be really quick. I would say I think most parents are very scared to be upset until they're not, and then they're like upset about everything. And so I guess I would say parents that I tend to work with are either like, I don't want to say anything bad, or like
that person looked at me the wrong way and now you're gonna hear about that, you know? And so, and look, I get the tendency to do that because when that switch has been flipped, you know, there's a reason for it. But what I guess I would say is like, don't be too deferential, but also agree where you can agree, right? Like in an IEP meeting, even if there are some bad actors, or, you know, usually not everybody at the meeting is like out to get you. That's not always the case. I've been in a couple, okay, I live in the real world. But I would just say, I've worked with some families who like had it and again, like they've had it for good reasons, but then it's like, we're fighting about weird things that we don't need to be fighting about because the relationship is so broken. So I would say steer clear of that level if you can help it. But do absolutely say what you need. My two other tips would be just ask them why they think something, like what data is that based on? You seem very sure of this. Why is that? Can I see it? Also ask for things in advance of the meeting in order to participate fully. Like you're supposed to be able to see that. And I think what happens so often is like you get to a meeting and there's 87 of them and they're all like nodding and telling you that this is how it needs to be. And they're like going over documents and assessments that you don't know what they mean. And it feels really uncomfortable to be like, I don't know what you're talking about. And also, why do you think that? But actually, that's really important. And you're well within your rights. Like that's what the IDEA contemplates, for there to be a sharing of information and a back and forth. And so I would just say, don't hesitate to request any of the information beforehand. Don't hesitate to say you're going to need some time to think about it. Ask a lot of questions and ask them, like, why are you sure my child doesn't need that service? ESY, whatever it is, you know, like why do you know that? Because that really, like, they should have an answer for that. Those would be my tips.
Good. Everything's been said. There's a couple of tools that I always use that take the tension down. One is to ask for the records when I get started. So I do a standard records request every time I start a case, and it takes a long time. We just wait for it. But then it's sort of like, I'm here, I'm representing this family, I'm going to be looking, so you better start rolling over and do it right. The other thing is to ask for evaluations. We often find that we don't have enough information. Like the testing hasn't been done for 4 or 5 years. They talked you out of doing a 3-year reeval. It's like you can't get enough good information on kids. You know, you can out test a 15-year-old or whatever, but I'd always say, let's do a sensory profile. Let's get a depression assessment on this kiddo. Like I want more information because to me, those are very valuable and they don't often get manipulated. I don't often find that someone has badly tested to try to show your kid knows more than they know. I think those folks have more integrity than them for the most part. Retaliation does happen. I will never tell someone, don't worry about that, because people are human and they get spiteful and vindictive, and some districts are worse than others for that. We won't name names, but then I guess the last two things are, I've started recording. I got a new iPhone, it's got a great speaker. Because who always takes the meeting notes? A person on this school team. And you can actually hear the bias a lot of times when they read it back. And today I was in a meeting and the person who was taking the notes stopped listening to the group and started transferring something from a piece of paper into the notes that we hadn't talked about. And I just got my phone and brought it up, because that person was no longer even listening to the conversation. So you don't have to tell. I don't try to be subversive. I get my phone out, I push the button and I leave it in front of me. So I'm not trying to hide. But these days people are saying things you just can't believe sometimes. And people don't believe you unless you play that recording. So, and I guess the last thing I'd say is, having been a teacher and a principal and had to tell a parent, no, you can't have an aide for your child when I'd already begged for one behind closed doors 2 minutes ago, be soft on the people and hard on the problem. Because, you might think the principal's the one keeping your kids in home services, but honestly, as a principal, I never had the authority to say yes. If I said yes to you in a meeting, I would have been in trouble because I don't have the money or the resources or the permission to give you what you're asking for. So try to keep in mind that for the most part, the lack of funding in Utah, this is my soapbox, is almost always the reason people will tell you no. If we had adequate funding, they'd be saying, here you go, have an aide, have a chair. but it's because we're starving as a system. And so until we advocate appropriately to get enough appropriate funding, they'll be guarding every penny like it's their own dollar because they know it's not possible to give every kid what they need based on the funding that we have in Utah.
Thank you. I just want to return one to the room if anyone else has questions, and also online. If there are any questions, feel free to unmute or type in the chat. I have one other question that I can ask the group, but first I'm gonna ask the group. Does anyone have anything that they feel like we haven't covered that feels really important to share with folks?
Gaslighting. You are the parent and there are 15 other people in the room. It's a little what Laura was saying about there's talking over your head, or even if you know what you're talking about, it's the force of all those people who feel like they've had a meeting before the meeting to decide what they're going to tell you. And they're all trying to leverage your feelings and emotions and get you to agree with them. That it's really a bullying. So like you apply it to bullying where you've got a power dynamic that's different. Your mom, you've got 15 people on their side of the table. So, don't wait too long to get help. I think what Laura said about they come to us and they're like irate and every little thing is annoying. It's because for 18 months they've been taking it on the chin over and over. So don't wait too long to reach out and get help from advocates, from attorneys, from the DLC. IEP Student Center is almost up and running, so you can call and get some assistance. So, don't wait till you're irrationally angry before you get some help and your kids spent 18 months not being served well.
And if you don't, Amy mentioned something really important, and she basically said that it's so important to have the information you need before you even have the meeting. And I've seen so many parents who they have the IEP meeting, the district presents the meeting, the information during the meeting. Parents aren't given adequate time. So even if you don't have an attorney or an advocate present, feel welcome. If that information is overwhelming or you're to the point where you're just numb because you've heard 3 hours of it, then feel comfortable saying, look, thank you for this information. I've had all I can process today. I'd like to reschedule for another IEP meeting so that I have time to thoughtfully evaluate this information that you provided and decide what I'm going to do next. You don't have to sign that IEP during that meeting. And if they try to force you to sign it, just say, I'm not going to sign it until such time as I can agree with what we've come up with.
And they'll use it against you whichever way, whether you
Yeah.
sign or don't sign, they have a way to say, well, you agreed or you didn't. Yeah. So
Yeah.
there's no right answer to that. If you feel like walking out and not signing, do that.
Yeah.
I will just say on the gaslighting, I mean, I think we all feel that way too. I mean, right? Like, at least again, I'll speak for the DLC, like we'll go to a meeting and then come back and have to be like, have I totally misunderstood federal law because of the way they're so sure in the room? And it does make you think like, what just happened? And like, no, we're not wrong. But I guess the point is like, if after, being a lawyer and going and arguing at the 10th Circuit and having a bunch of due process hearings, you can still be in a meeting and you're like,
Wait, what?
Yeah. Then of course that's how people are going to feel. And I think if you go in expecting to have that moment, it's a little softer when it comes. Again, I think that was a really good point, Amy. Like truly almost every meeting still, I'll be like, that is a new one that I had not heard. And I'm going to just ponder on it for a moment while I decide why it's so wrong. But I think it just happens. And again, there just hasn't been, I think, the sort of pushback in Utah for such a long time that just so many things go unchecked that there's also just a lot of myths circulating out there that I think like really well-intentioned people like sincerely believe. That doesn't make it okay. It just means like, it's hard in the meeting always to know how to handle like a deeply ingrained bunch of nonsense. Like you have to figure out how to address. So I don't have better words, but I do.
It's a systemic problem and
Yes.
it's deeply ingrained, and for all of us to be nodding, yeah, we've all seen it. And for us as attorneys to experience that, it's it's even more likely to happen to people who are lay people who don't have the day-to-day experiences.
Well, there's so few of us, like we represent 50% of the folks out there doing this at the moment, so between us, there's only 5 more besides us that are actually doing this work. So, we've tried to come together just this year to be like, hey, is that right? What do you think? So only recently have we been able to verify our thoughts and beliefs with other people who are like, no, you're right, it's okay. And that's what parents that come in, the best thing they can get from us sometimes is, I'm sorry. We may be the only people that ever tell them, I'm sorry that happened to you. And then to say, and you're right. You have read IDEA right. You understand that rule. That is what they're supposed to be doing. I'm like, thank you. Like I thought I was nuts. So those are, you can help others as you're advocating. Just have somebody say, that is what it says and you're right. Just because they haven't ever done that doesn't mean that we're wrong.
It's a great point, because I can't tell you how many meetings as a parent, I'm sitting there thinking that exact same thing, except I can't keep it calm.
You don't have to.
It goes.
It happens to all of us.
I'll give you my pat phrase. I just go, that's not a thing. No, really, it's not a thing.
That's absolutely right. And I think for me, kind of a light went on when I realized going into a lot of these meetings, also feeling like this can't be real, have I just like fundamentally misunderstood like this entire body of law that, I spend all of my time doing, and, because I feel so strongly that something is a certain way and I go into these meetings and they are acting like I'm on another planet or saying things that seem like they're entirely reasonable and uncontroversial. And at some point I realized that and this is a little bit to Amy's point a while back about like who is really in charge for these decisions. Like there are a few things that you have to know about like special education and the way that it works. And it's that everything is about the biggest thing is that everything is about where the money is that's going to be paying for a certain service, who's in the room that's being providing this service, and where is their payroll coming from, and any obviously assistive technology accommodations, other things that play into a school district's financial piece as well. The thing is that like a school district is not allowed to justify whether like a certain decision is going to be made for an individual student on the basis that there aren't the resources to do it, or it would be more convenient, or we would be able to manage our resources more effectively if we did it this way. That is not legally speaking an answer. They're not allowed to use that as a justification, and they know that. And most districts have gotten at least smart enough to know that they're not allowed to say that outright. However, in almost every single school district I've been in an IEP meeting for, these things are actually playing into the decisions that are being made, and everybody knows it. And it's sort of how the task for the school district administrator becomes, how do I basically get back around to we're not able to afford this without actually saying we can't afford it, basically, because they know that they can't say that, and that the moment that they use that as a justification, that me or whatever annoying little person is going to come and call them out on it, is going to say like, well, that's not a justification. If they're going to say, well, we can't do that because it's not something that's in our budget, I'm going to speak up and say, well, that's not a justification. You guys are responsible for finding a way to make it work if it's something that you've identified that a student strictly needs in order to benefit from their education. And so knowing that knowing that system is constantly at play, like there are this complex dance of resources that's always going on in the background that everybody knows is happening, but nobody is allowed to actually acknowledge. Knowing that, it makes it a lot more clear why the weird arguments that get made, the weird things that people will tell you in those meetings, it all starts to make a little bit more sense. It doesn't make it any less infuriating, I guess I would say, but I always have to try to keep that in mind. And it doesn't do me any good to, go off accusing some people, well, in reality, you guys are actually just trying to manage your resources and you're denying this based on this. That doesn't really help to go in guns a-blazing, but to know that's what's going on in the background, to be able to say the right things, say the magic words that gets us back to what does this student actually need? Because whatever the student needs to benefit from their education, that is something that they're entitled to under the law. That's consistent throughout the law in every situation. If there's something a student requires in order to make appropriate progress, that's something the school district has to move heaven and earth to find out how to get there, basically. So your task as a parent advocating for things the school district doesn't want to pay for is getting it out of that realm of talking about money without talking about money and into the realm of this is something my student, capital N, needs in order to benefit from their education, basically. And if you can get everybody to acknowledge this is something the student needs, let's get that on the IEP, then that basically gets you where you need to do, because then you've won essentially. This is something my student needs to benefit. You guys have to provide it. You have to find a way. It's not my job to find a way. You guys have to do that. So be a little confusing.
Can I ask, you said they're never gonna say that, right, outright, but what will you hear instead from an LEA?
They'll say they'll say things that come pretty close to that. They'll say things like, we don't have enough room in this class. They might not say outright like, well, this service is not something we're able to provide because of that. But they'll say like, well, we would love that, but we simply don't have room in the classroom where that's offered, so we're not able to do that. So there'll be, some sort of justification based on that. There's a thing that goes around more recently that has been, the eternal, like my the bane of my existence as a special ed attorney is this, anytime a school district wants to justify doing something, they'll say, well, that's part of the location. That's not part of the placement. Because they know that a student's placement has to be strictly based on what the student needs in order to get a FAPE. But they can do all sorts of stuff with where things happen, the location of a service. They can do all sorts of stuff with that legally and technically get away with it. But they can't, just arbitrarily say that something has to do with location when in reality it has to do with placement. But they'll say things like, this service that is specifically tied to this particular classroom, the service is actually nothing more than a factor of the location that services are happening. So we're allowed to set that and predetermine where these locations are going to happen. And the fact that you're not able to get this service by virtue of the fact that we've foreclosed you from going to school in this location, that doesn't matter. It's all just, that's the location where we offer these services, and we have absolute control over location. So, and anything that is, anything that speaks to what your students' actual experience in the classroom, things that we would, in any normal world would consider to be part of the student's placement, they'll go to extreme lengths to make sure that people in the IEP meetings don't use the word placement. They'll make them say location instead of placement. They'll, say all sorts of things. So if they can characterize something that's actually part of the IEP as being just something administrative, that's like, well, this is just, housekeeping stuff that we handle. You don't actually have an individualized right to individualization in this particular area. If they can compartmentalize it in that way, then they'll try to use that as a justification. So it's usually something to that effect. Basically, I've seen like any number of different things that you use as justification for why a school can or can't do things, but those are a couple of examples, I guess.
You heard, nobody does that.
Nobody does that. I've heard everybody does that. This is just the way that we do things. That's another one. So you'll hear, our district just is the way that we're set up. This is the way that we're going to do stuff. And we can provide everything that's on your IEP. We can provide that in this other location, but you're going to have to accept all of these changes to the IEP. So we can implement your IEP, but we actually have to change it a whole bunch. So can we really implement your IEP?
It's a little like what Amy said too, that like, we don't need to put that on the IEP because it's like inherent in this other whatever that we do.
Yeah.
It's a lot of that.
Yeah. Anything that they can make disappear from the IEP, they can then use to, because it is all about like your IEP says what your IEP says. If something's on the IEP, that has to be provided. But if they can turn an IEP service, wave their magic wand and turn an IEP service into some, like nebulous thing that doesn't really exist, then they can start making all sorts of, it becomes this cup and ball game of, have they materially altered the education program? If we've changed this, and this, and this, it's like the Greek ship, you replace all the parts of the ship, is it still the same ship? They're able to do that sort of thing with the IEP by saying, well, this wasn't on the IEP because this was just something we had, verbally agreed to. And so that's actually not part of the IEP. So if we change something that affects that, that's not actually going to speak to whether it's a change of placement. This is just going to be, some administrative thing, and so meanwhile, you start finding these changes start racking up, and the changes the school is pulling behind the scenes on the guise that this is just a location-based thing. This is just admin stuff. It starts to get more and more substantive, and before you know it, your kid has a completely different educational program than they had before, and you've never even had an IEP meeting to talk about any of the stuff that went into changing it, basically. So you have to be really careful about what happens during an IEP, what is supposed to happen during an IEP, and the sort of changes that really are the purview of something the IEP team should be deciding, and not some random committee of school district people.
The one I hear the most is the data doesn't support that your child needs. And I've even said occasionally, so what data would that be so we can start collecting it to show that he does need that? And the person laughed. And I was like,
yeah.
no, I'm not kidding.
It's really good experience, because something I was going to say earlier is, like, even if you get to like that conversation, I've seen parents kind of deer in the headlights when this happens, but they'll say like, well, I don't think this placement is really justified based on my student where they're at. And the school will be like, well, actually the IEP team, we've all come to the conclusion, based on the data and the progress reports, this actually is where your student would most benefit from. A lot of times parents will be like, oh, well, geez, like, I guess that really is, like, no, absolutely. Okay, well, I'd like to see that, and I'd like to talk about whether that actually means what you're saying it means. And if we need to drag the provider who actually wrote this report in here to be able to clarify, any sort of terms, and, be able to interpret, because those neuropsych evals, you end up having to read, folks, even, folks like us here, we're really great at what we do in terms of the legal side of things, but I'm not qualified to interpret a psych eval, and know exactly what the clinical kind of implications of that are. And, to have a parent, to be put on the spot and try to, arguing with the school district about, does this psych eval mean what they say it means? You need to have somebody there who's qualified to be able to interpret those results, to be able to make that happen. So, if something doesn't sound right, trust your gut, basically. If you don't understand, if the school is saying, well, this actually is supported by the data, make them put that up, make them actually go through the data and show, yes, as a matter of fact, this is supported by the data, and if it isn't, if it turns out they're just, giving you a bunch of BS, then you can call them out on that, basically.
Thank you, everyone. I think we're very near to done. I just want to revisit if anyone has any questions. The only thing we haven't really talked about, we don't have to, but if anybody wants to. The only thing we haven't talked too much about is behavior. And I do think that that's a really important area that a lot of people have questions about, right? A lot of parents have questions. And so sort of the thing I'm thinking about, and I think we can close with this question unless anything else comes up. So if a student's disability results in behaviors at school, what rights does a parent have on behalf of that student? And also, what are the district's obligations around behavior? And there are a lot of directions we can go with that. So I'll open it up to the panel, and if we need any more drill down questions, I'm happy to add some follow-ups.
I have lots of these days. I do a lot of discipline, but to me, the thing that's going wrong, like why is it so hard, is we're not giving specifically non-verbal students or non-speaking, depending on who you ask, the communication skills they need to be successful. So you get to be a 14-year-old boy who normally wants to have his way and express himself. He doesn't have sign, he doesn't have spoken language, he doesn't know how to use an AAC device, and now he's hurting people because behavior is language. And so what I'm seeing is that our failures before that point are coming to a head, and we're having tough times with teenage boys because we haven't given them any means for communication. And I think that if we look at behavior throughout the years as something a child is doing to try to get their needs met, and not look at them being naughty or parents been lenient, or there's all of these judgments that come about behavior that, I even had a colleague whose adult son made a mistake and she was devastated. And I was like, it's just behavior. This is still your cute, lovely boy. We can fix this. Behavior can be modified. Behavior can be adapted. And I separate that from the human that's having the behavior. So I think sometimes people get tired of working with a particularly hard kid and they start to resent that particular child. And, if you could just say for a minute, just separate, we can adapt this, we can change the behavior. The kid is not bad. They're just trying to get their needs met. And I think as more we can help people see that through that lens and be less judgmental. People in the grocery store who look at your kid lying on the ground like, what are you doing, mother? There's a lot of judgment out there. If you're a good mom, then your children will behave well, and it's just simply not true. So.
Something that I've seen a lot, and this speaks to me personally as well, since I am a person who's on the autism spectrum and have had a lot of interactions over the course of my life with intersections of disability and the expectations of public life and all of that stuff. Something that I hear a lot in, not just in the context of disability, but in the context of kids and discipline behavior, just sort of in general, is this idea that kids are manipulative, that children are just sort of by nature designed, they're always trying to get their way and they're sneaky, they're always trying to trick you into doing things, and that you can't trust children because they're always basically being a little 007, trying to foment dissent and cause things behind the scenes. So and obviously like we laugh because kids in some ways are tricky and they do like to come up with ways of getting their way, but we don't think about the fact that that's how everyone is, basically, especially up to a certain age. When you are a child and you haven't learned how to communicate your wants and needs yet, you figure out ways of getting those wants and needs met by any means necessary. This is evolutionary, going all the way back to our evolutionary science sort of stuff. Like, this is very deeply ingrained. You're gonna seek out. It's all about survival, basically. And we as adults have learned that you can't be sneaky and try to hide your motives and try to get things from other people without telling them what you're after, because we've grown and have learned as adults that that's not what the expectation of society is, and you should communicate your wants and needs directly, rather than trying to trick somebody into giving you something that you want. But as a child, you haven't necessarily learned that yet, and so I think it's really easy tendency for kids with complex behaviors to look at those kids with complex behaviors and see like Amy was saying, like a naughty kid who's just trying to cause chaos, and he's just really got a little heart of darkness going on, and is just trying to cause trouble, basically, and understand that, like, even if there is some element of like, yeah, this person is trying to do something to manipulate and get people to do what they want, this isn't some sort of like insidious evil sort of thing. Like, we all have done this when we were kids, and we learned to stop doing that, basically. And children, if they haven't learned how to properly manage their emotions and their wants and needs and communicate appropriately, they're not going to be able to do that, basically. So I think people put a lot of like malice onto kids with behaviors. I find that like 99% of the time, if a student is exhibiting behaviors in classroom, they just don't want to be there, quite frankly. They're sick and tired of being in the classroom. They would rather be somewhere else. And anybody who is standing in their way is just catching the crossfire, basically. They just don't want to be there. They're miserable. They have learned that school is a miserable place where miserable things happen, and they have their rights taken away from them, and they have to sit still for an extended period of time. And there's all these expectations of them, and they just know that that's not a place that they want to be. And being in that place makes them frustrated, and they're going to act out in the only way that they know how, whether they're even thinking about it or not, to try to escape that environment, basically. And if you were in a similar situation, a lot of us would behave in pretty much exactly the same way. We don't think about how much is expected of kids who haven't even gotten the faculties to be able to maintain appropriate behavior in a lot of ways, who don't know communication nearly as well. And we put these intense expectations onto them, basically. So really, I guess what I would have to say is, like, there needs to be a little bit more grace. We obviously don't want kids to be engaging in aggressive behavior, doing things that are going to be disruptive or cause problems, hurt people. Obviously, we don't want those things to happen, but it's so much easier, and yet so, it doesn't do anybody a service to just look at this behavior and say, this is just a student being bad for the sake of being bad. It's communication. Like Amy said, it's always communication. The question is always, what message is trying to be sent, and what's a better way for that message to be sent, rather than engaging in this behavior, rather than just treating it as this pathology.
So one other component, I think, is to write into the IEP a specific process for what needs to happen if a child becomes volatile. So it might look like, The child may need to be removed from the room. There may need to, the rest of the class may need to be evacuated. The child, one strategy might be to teach the child to self-advocate before he or she gets to that point, so that he or she is saying, can I take a break? And then have a designated place to go to. And those types of interventions are helpful, not just for the child who has a disability, but they're helpful for all the students. And I think that I think it's perfectly fine to have a child who might become violent in the classroom, remain in the classroom, if the processes are set up so that that child has the support that child needs, at either before the child becomes violent or when that child becomes violent. I think a lot of what I've seen is that those processes and those safeties aren't implemented or aren't included in the IEP, or lip service is given. And then when it actually comes down to the point where somebody needs those services, they're just not available. So, and those, they need to be very concrete. This person will go to this room, this person will be escorted by so-and-so. If so-and-so is not available to escort the student, then, and it needs to have a backup of about 3. If there's a substitute, these things need to happen. Can you think of anything else?
But just say something to that too, though, just as like my daughter doesn't have extreme behavior stuff, but the thing that even though she does show behavior, but it's in the beginning it was communication and it still is communication, but she's able to more express the source of the issue. And because I'm very much at her environment, I know kind of what the core triggers are. It's been a various things throughout the years. But really figuring out what can be done to prevent the behavior in the first place. So instead of it being reaction oriented, which is always good, that obviously, especially with certain kids have a plan in place for a difficult situation. But what I've like been in conversations with my daughter's teams is like PBIS, like let's eliminate the trigger.
Right.
So that we don't even have behavior. And like it's interesting how often you have to have those conversations of like, you know, don't look at her as the problem whenever there's these other things that are actually causing the behavior. That if you resolve those, then that behavior isn't the issue, and then she can have a successful education because that problem has been eliminated.
I would just say, I know we're over, I'll be quick. Like, a functional behavioral assessment is a good tool, but like, if it's done well by somebody that knows what they're doing, because I've seen ones that say, when we're talking about the function of the behavior, and it'll basically be like, didn't observe this behavior. And then there'll be like a plan developed off of like, they like, well, how would you develop, like, you didn't deserve, like, you know what I mean? So like, we can't just like check boxes for the sake of checking boxes, because behavior is communication, but that means you have to have somebody that like knows what they're doing when they're observing kids, and knows how to put together, you know, a behavior plan, and knows how to train staff. And I think so often, like Amy said, like we have failed in that, and then we get to like a crisis and we act like it's the kid's fault, when like really it's because like that kid never had what they needed, and that was on the system, right? Because like that kid needed more individualized support. Like maybe that kid didn't need to go to the behavior cluster class where then they learn like 5 new fun behaviors, you know, that all the other kids had. And I think like that's also harder and requires more sort of like thought and individualized services that are just like really hard. And that's not what people want to provide, you know, like on the AAC too, you know, like have clients that desperately need to communicate, and it's like, well, this is what we give, this is our AAC, these are our minutes, and it's like, well, but maybe that does or doesn't work for that kid at all, you know. And so I just think it like really goes back to the same things we've been talking about. It's just that I think with behavior, the consequences can become so much more severe because it escalates so fast. So
I'll end with one quick success story that's one of my favorites. So 6th grade boy, taller than I was at the time. He was attending 2 hours a day for more than 6 months because he was aggressive. So my staff and I, we did this enormous spreadsheet and we took every single behavior sheet. Like, okay, who was there? Was it before lunch? Had he had a snack? We just graphed every single component. And it finally came down to, we stood back and was like, what is it? They were putting him in exclusionary timeout, which means the aide and the kid, and setting a timer for 3 minutes, which during that time I would beat the crap out of the aide, and then they would put me in seclusion. I'd be out in 45 seconds. It's like for a year and a half, the exact same behavior. So staff was getting hurt, scratched, bit, kicked, and I finally just said, just stop doing that. Just go into seclusionary. He'll be out in 45 seconds, and you skip that part. And it was. They were just too close. They've been doing it too long and we're too close. It was a great team. And once we said, please stop doing that, try this instead. He's not perfect. He has bad days. He's kind of has a seasonal time period that gets worse over, everybody sort of has that, but he's back in school full time and has now done it almost 18 months. So it's just, you just got to figure out like, what is the thing that we're all doing that's contributing, and there's a magic solution for most behaviors if you just pay attention to the kid and figure out why. So it can be fixed. You have to be persistent and creative.
Well, thank you, everyone. Thank you, panelists. I feel like we had a really robust, informative conversation today. So thank you all for joining us. Thanks for those who are here and who are online at various moments during the meeting. We really appreciate you all joining us. We'll send you off into this dark, cold evening.
Thank you.
Thank you.